Hang on. Wait, hang on a second.
There were some recommendations to add the new financial wellness competency piece to the C2EX program. Under conventional financing, they approved a policy that NAR opposes the sale, exchange, and use of trigger leads for marketing of a mortgage loan. I'm sure some of your buyers are complaining that after they close, they're starting to get calls from security companies or insurance companies or, all sorts of people offering services. And we're taking a position to oppose that because of the potential violation of FTC rules under unfair or deceptive acts, practices, and the National Do Not Call Register. They gave us an update on some of the legal issues that are going on, the class action suits, but they also granted some funding to the Massachusetts Association of Realtors and the Hudson Valley because of some lawsuits they are involved in that would have a national impact. Under federal financing and housing, there's a recommendation to support policies, regulations, and programs that enhance assumable mortgage products for federally insured funding, such as FHA, VA, and USDA. Under business issues, they approved a policy that NAR will encourage federal efforts and collaboration within the real estate industry to support programs that will expand the workforce in the construction industry to relieve labor and housing shortages. Y'all may all be familiar. We did a lot of that post-Katrina, Rita, Ike, Gustav, the numerous storms. Through the technical college, they had a center of excellence for construction. We created internships and things of that nature. Well, now they want to, NAR is thinking about how to encourage that to occur at the federal level as well. Under federal taxation, they approved a recommendation to support the tax policy to provide a reduced capital gains rate to existing owners of qualified 1 to 4 unit rental properties if you're selling to an owner occupant. So you would get some capital gains relief on that. And the biggest thing y'all need to know is their budget was approved with an increase of dues of $6. So for 2024, your national dues will be at $156. And that's really the big items from there. We had several members recognized and inducted into the Realtor Party Hall of Fame for lifetime giving. At the $25,000 level, Kim D.G. Ovani, and I'm sorry if I mutilated that name, Logan Morris and Mark Uchley. At the $50,000 level, Bruce Roberts and Connie Kyle. Carol Horn was recognized for the $75,000 level. And Miss Carol was also given the Federal Political Coordinator Meritorious Service Award, which is a big award for her. She's worked really hard over the years supporting federal candidates. So with that, unless anybody has questions on the NAR update, we'll go to the commission. Does anybody have a question on NAR? Okay, and there are 2 people waiting to get in if somebody can let them in. And so I'm going to turn it over to Summer Muir, who is the Real Estate Commission Executive Director. I know there's been y'all have seen a lot and people have questions about the new fingerprinting and background checks. We also want to hear a little bit on the comments and the next process for the contracts and disclosure. So Summer, if you're ready, It's all yours.
All right, thank you, Rhonda. I appreciate y'all having me on this afternoon. Yeah, so let's start off with the comments that we received for the property disclosure document, as well as the mandatory purchase agreement. So between, I believe, Louisiana Realtors and the commission, we received around about 300 comments, I think, total. So we are currently going through those. We have a kickoff meeting next week with the work group so that we can kind of get a discussion on when we're going to have that first initial work group meeting. So that meeting will take place, and then from there we'll have those comments then given to the actual standardized forms committee for the commission. So the ball's rolling. We have all the comments in place now, so now we're just going to get to work. So we'll have another update for that once we get those meetings going. For the fingerprinting process, I believe everyone probably in the last week or two received an email from the commission with the important notice that notifies everyone that the new fingerprinting process will start on July 3rd. So we're about to start off with our hard copy mailings. Everyone should be getting actual hard copy mail letter starting next week. But that will basically say that anyone that is a new initial applicant for either a salesperson or a broker's license will be required to go through the fingerprinting process with Louisiana State Police and the FBI. So if you do have any people that are coming to your brokerages that are looking to sign up to be an initial salesperson, I would recommend that they start that process first, because it could take a few weeks, anywhere up to, it could take a number of weeks for those results to come back. So that will probably be the biggest holdup on that in that actual initial process. So we do recommend that they start that early. We do have a frequently asked questions page on the website. If you go to the Real Estate Commission website at lrac.gov, there is a pop-up box. If you click on that, it will take you to some frequently asked questions. It will go over the cost of the form, the cost of the fingerprinting that has to go directly to state police. Also the 2 forms that they will need to fill out as well. And then any questions about where they can go get fingerprinted. It kind of covers all of those options. We have had a number of questions about whether or not you would have to have this at renewals. Absolutely not. This is not a renewal fingerprint process. It is only for initial applicants. So if you are applying, if you're currently a salesperson and you want to get your broker's license, then you would be required to complete that background check. If your license expires and you're wanting to reinstate your license, then you would have to go through that process as well. But for renewals, just a regular renewal of your license, there will be no requirement to have that fingerprint process done. So I'd be happy to answer questions if anyone has any questions on the fingerprinting process. I'd be happy to take those.
Put the link up in the chat for you guys. I know they've been heavy on social media with the requirement and all the recommendations.
I would like to say, if you do have sales meeting with your brokerages, if you would please, push that Facebook page, let them know that our social media site, we do have a new public information director. So he's been putting out new informational videos, and we're going to continue that as well. Everything that we do is generally done through email. Again, because this is such a big change, we will be putting out some hard mailings, but please stress to your licensees that they need to keep an updated email address with the commission, because anything that we send will be going to the email address that we do have on file. So Facebook, if you can push that, that would be fantastic, as well as notifying them to follow us on social media and the email addresses.
And we know the commission met this morning. Was there anything exciting coming out of the meeting this morning?
Well, so we did decide on the mandatory course for 2024. So the commission is going to go ahead and go forward with the same type of process that we did this year, or the same format in the class, where we're going to have the little hour modules. Because the contract, we haven't actually had a full contract review since 2013 as a part of the mandatory courses. So the commission did vote to have 2 hours on the mandatory buy-sell agreement. We'll have 1 hour on the property disclosure documents. And then that last hour will be on hot topics, current trends in the real estate industry. So we're looking at maybe discussing wholesaling, fraud, anything, advertising. Advertising has been a big question and a big issue. So we are going to be pushing that in a little, in an hour of current trend topic on that.
I think advertising is always a hot topic.
It is always for sure. And that was the main thing that came out of the meetings today. So again, if anybody has any questions on any of those topics, I'd be happy to answer any.
All right. Well, I'm trying to see. I don't see anything in the chat. Everybody's good with this new process? Y'all understand, start early, not later?
Yep, definitely
Mhm.
start early, not later. And just remember to stress to them too, that the forms that they fill out for the fingerprinting process does not come back to the commission. We don't keep any of the fingerprinting documents here. They go straight to state police, and then state police then sends us the results that we have to keep under lock and key. So don't send those here. The commission will have to send them back to the applicant, and they would have to go forward with sending them to the state police, which would just hold up the process a bit more.
I'm not sure I understand.
Sorry. That was my watch. It didn't understand me, apparently.
Perfect timing, huh?
Yeah.
Kim, I don't see Jeremy on yet.
He's
So-
not, but Matt is on.
I know. So we're just gonna jump ahead and Matt, I know I'm gonna say your name wrong, even though I heard it 3 times last week. Matt Troiani is the Senior Counsel and Director of Legal Affairs at NAR. He has over 16 years experience representing associations and organizations. So we're going to let him talk to y'all a little bit about the ADA website compliance. We know several people have gotten notices from attorneys or threatened that your website's not compliant. He's going to kind of walk us through how to deal with those. And that's almost perfect too. It's whistling for you, Matt.
Well, thank you. And by the way, got my name perfectly, so I appreciate it.
Oh, I paid attention then.
It's those 3 vowels in a row always trips everybody up. Good afternoon, everyone. It's nice to see you. I'm gonna, if you'll give me just one moment, I'm gonna pull up my my presentation here. That way I've got a little something to guide us through. And then we will start from the beginning. So my name is Matt Troiani. As was mentioned, I'm Senior Counsel and Director of Legal Affairs at the National Association of Realtors. I'm pleased and greatly appreciate the opportunity to come and speak to you all today about website accessibility. That's a riveting topic, is it not? But before we get into it a little bit farther into the details, I like to start big picture. That's just kind of how I approach things. So what we're going to be talking about today is why this matters, a little bit of the muddle that exists in the law right now, how that actually pertains to your day-to-day business, and then leave you with some practical tips, risk management tools, and best practices to respond. Because the context in this, I'm sure, is that there are some very enterprising members of my profession who feel like they can maybe get a quick buck by sending out just blasts of these email or these letters, demand letters, saying you're in violation of X, Y, and Z, even if the law is not entirely clear on it. When it comes from somebody with Esquire on the end of their name, it seems to be a little bit more persuasive, puts you on the back heels, and you're thinking, okay, what do I do now? The good news is that because the law is not entirely clear on this front, they actually would have the burden of demonstrating that you are not complying with the law. That's a good place to be in, believe it or not. So until we have some greater clarity, which we do support and have been trying to work on, our takeaway is that chances are you're probably not liable. There's some things that you can do in order to protect yourself fairly simply and to ensure compliance going forward. But the risk of actually monetary damages and things like that is fairly minimal at this point. So we'll start with the good news. So when we're talking about ADA website accessibility, we're talking about the Americans with Disabilities Act, came out in 1991. So you'd think, oh, this has been around for over 30 years. We should have some clarity on this. The law moves at a snail's pace. And frankly, it moves even slower when it involves things on the internet. I don't know if you've seen the average representative at the federal level, but I can assure you that most of them are not digital natives. So when we're talking about the ADA, though, we're talking about public accommodation. Remember, this can be distinguished from fair housing. You all, being public businesses, providing a public service to others, it does mean that you are a public accommodation and therefore would be subject to the ADA. but that has different standards and frankly, significantly lower standards for the most part than you would expect in the fair housing realm. So I just like to get that out up front, because sometimes when we start talking about disability, people can get a little bit, confused, understandably so. So we're talking about places of public accommodation that are required to ensure effective communication with individuals with disabilities by providing them with auxiliary aids and services. That's a pretty broad statement. So what does that actually mean in practice? Well, the DOJ says very helpfully, all websites should be accessible. Great, done, we're good to go, right? Unfortunately, of course, the devil is always in the details. So the good news is that a little over a year ago, the DOJ actually did provide a little bit of guidance and a list of resources. By the way, you all can feel free to copy this website down, but I have provided it to the Louisiana Realtors so they can circulate these slides to attendees afterward. So they have a list of resources for businesses to bring their websites into compliance with the Americans with Disabilities Act. But here's kind of the money quote, and this is something that I like everybody to take away from this. Businesses have flexibility in how they comply with the ADA's general requirements of non-discrimination and effective communication, but they must comply with the ADA's requirements. So what that means is if you get a demand letter and that letter says you have not complied with the WCAG requirements, and they'll throw out a bunch of numbers like 2.0, 2.1, 2.2, things like that. That does not automatically mean that you are not in compliance, because the DOJ and the federal government has not yet adopted that standard. What it is going to depend on is the extent to which the people who are seeking out your services have the ability to access your website. And the good news is that you don't have to do all of this alone. You don't have to figure out how to program these things. There are resources that are available, and the DOJ highlights several of them. So that's the general picture. Now, like I said, the devil is always in the details, and unfortunately, that's why we have lawyers in courts, because the law is not always clear on its face as to what that means. And the courts, frankly, are not consistent on this point yet. We have what is called a split in the circuits, which you'll see here in a few moments. The Ninth Circuit, which is out on the West Coast, has adopted a pretty stringent standard, but with some flexibility based off of where people are accessing the website and where the physical locations of businesses are. With the First Circuit, which is up in New England, they have a different test. The Seventh Circuit, which is in and around Chicago and the upper Midwest and the Great Lakes, has a different standard. The good news is for most of the Southeast, which includes you all, they have not adopted any particular standard yet. So it's a little bit more flexible for you all down there. So right now we're taking a look at situations where somebody is saying that they cannot access a business's services because of something that is not included or is included on their website. Now, usually the question is, do they have a physical location? Because it's no question that with the Americans with Disabilities Act, unless you're grandfathered in, for the most part, you need to provide accommodations so that people can physically interact with your business if you have a physical location. Thinking of accessibility features and ramps and things like that. You will see some places that put up signs in Braille or have like hearing assistance in order to enable people to work with your business in the physical context. Well, with the presence of the internet, courts are starting to look at the internet as the place where it is actually essential in many areas for you to actually be able to do business with people, even if they have a physical location, the business has a physical location or not, because the way that you work on things is you go on their app or you go on their website, you place an order, you submit a service request. So that's why the ADA is now getting tied up in what is happening on your websites, because of the argument that whether you have a physical location or not, the necessity to interact and receive non-discriminatory, the full services from the business means you need to be able to interact with them on the website. So one of the first cases that came down, this was a question of Domino's. Domino's, as you know, has lots of physical locations, but usually when you're going to order something for delivery or for pickup, you're going through an app or you're going through a website. And so this plaintiff said they wanted to order a pizza or, a series of orders, and they claimed that Domino's violated the ADA by having an inaccessible website. And the court actually ordered Domino's to bring its website into compliance with the WCAG 2.0 standards. This was out in the Ninth Circuit, not particularly surprising. But what they did say was that there is what's called a nexus test. So there has to be some kind of nexus between the physical location and the website. So here, because Domino's essentially was requiring people to go through their website in order to access their services, to order food, that their website then had to be accessible. Otherwise, it was a denial. It was discrimination of persons with disabilities from the services. But there had to be that connection between the website and the physical location where they were actually getting the food from. In the Southeast, I think Winn-Dixie, I think this was a Fifth Circuit case, which is in your all's neck of the woods. They actually found that websites are not places of public accommodation under Title III of the ADA. So therefore, Winn-Dixie's website was not an intangible barrier to a disabled consumer's ability to fully and equally access the goods and services of the store. They could go to the store. And therefore, the fact that their website was not necessarily accessible to all persons with disabilities was not in and of itself a violation of the ADA. So now you're starting to see how the courts are breaking down on this. So I mentioned before that this is kind of what the lay of the land looks like. The blue colors are places where this is the Ninth Circuit. They need to have a physical location is required. There's a nexus there to the website and the physical location. You'll see much of the rest of the country has not adopted any standard one way or the other. The Seventh Circuit, Wisconsin, Illinois, and Indiana does not require a physical location, and the same for the Northeast in the First Circuit. So these are the cases. This is from the Seventh Circuit, the Southern District of Indiana, Wright v. Thread Experiment. Title III does apply to websites even where there is no nexus exists to a physical store. However, it should be noted that even though they did find that there was some accessibility requirements, the court also denied plaintiff's request that the defendant must comply with the specific WCAG standards. Like I said, there has been no uniform standard adopted yet. The plaintiff may monitor the defendant's, and the plaintiff was not entitled to monitor the defendant's compliance. The defendant was not required to retain a specific consultant to bring their website into compliance. And the defendant was not required to adopt policies and practices that go above and beyond the requirements of Title III. So what does this mean? Essentially, the court was telling the defendants, well, you did it wrong, but we're not going to tell you how to do it right, which is not a great place to be in. So this is kind of where we are at this point. So what does it mean to have an accessible website? Well, it depends on the type of disability. There is a wide range of disabilities that could technically qualify under the ADA. The most common ones that we would think of are related to vision and to hearing. If a person who is blind or has low vision is trying to access a website, then there are software products that are available that can help them with screen reader technology or will translate text on a page into Braille on a keyboard, which they can actually use their fingers then to read. If they have low vision, then text reciting and color contrast. These are things that are all possible, or you could have audio that actually explains to a person what the video or the text says. The good news is that you all don't necessarily have to do all of these things programmed into your website. What you can do, though, is you can work with your developers, your web developers and things like that to make sure that people who have this type of software or technology are able to access your website. It is more of opening up the programming in order to interface with these software and hardware rather than you actually having to do it yourself. Similarly, when we're talking about deaf or hard of hearing, they can have captions for audio content. You'll notice that almost anytime NAR has any kind of webinar, anything that we do online, everything is closed caption enabled. For mobility issues, keyboard only access, the ability to slow down or turn off like timeouts and things like that. If your website has like scrolling or dynamic features, it will allow people to slow them down so that they have the opportunity to process them. And then, believe it or not, epilepsy is also included on there too. I don't know if you've noticed, but sometimes when you go to the movie theaters now, they'll actually give you a warning as to whether or not there is content like flashing and strobing lights and things like that that are warning people that it could induce an epileptic seizure. And so that's the ADA is actually responsible for those developments in things that you'll see at home and in the movie theater. Okay. So where does that kind of leave us? Because like I said, it is a little bit muddled right now, right? Well, we've actually supported efforts by the government, whether it be through the regulatory process or more preferably through the legislative process, to bring clarity around this. So we actually did support an Online Accessibility Act. Now, it did not pass in the last Congress. So we're hopeful that this or something similar will be reintroduced again at some point. As you know, the federal legislature has some bigger fish to fry right now, like keeping, paying debts and keeping the government open. So at this point, though, what this would create is basically a uniform standard that any private owner or operator of a consumer-facing website or mobile application, it would say that you would be compliant if you were in substantial conformance with a certain established standard like the WCAG requirements. But if you provide an alternative, you just be able to have to demonstrate that the means of access are the same. But I think most importantly, what it creates is a cure period, creates breathing room. So if somebody sends you a demand letter, it's not automatic. There's actually a process that's in place. You would have, for instance, if somebody sent a demand letter, 90 days to investigate, look into it, and demonstrate why you're either compliant or make the recommended changes to become compliant before a plaintiff could actually bring any complaint with the regulators or file a suit. Then the next step in the process would be that they'd have to alert like the DOJ, which would then have a certain time period to conduct its own investigation and review and make recommendations. All of these things are trying to get towards compliance rather than just giving somebody a payday. Like I said, the bill has not been enacted, but it is, it's just a good rule of where our thinking on this at is to create some predictability and create an opportunity to fix these things before you end up in litigation, have to pay a lot of attorney's fees or pay damages to an enterprising law firm and or plaintiff. So we're currently on the WCAG 2.1 AA guidelines. I'm sure they'll continue to add letters and numbers over time. They come out with a new one of these about every 2 to 3 years, and it seems to be accelerating. So these guidelines, though, are generally helpful. You can find them online, or when we get into the best practices, I will talk a little bit about your web developers. They are going to be familiar with these kinds of guidelines. So if you bring this up, that at least means that you can have an informed conversation about it. So what do the courts say regarding what happens if somebody does bring a complaint and then you get into compliance? Say that for some reason your website was not accessible to a person with some kind of disability. Well, the courts have been finding that, well, if you actually take prompt remedial action, that renders the claim moot, meaning that there's no more damages. So even though the online Accessibility Act, sorry, I thought it was OOA, the Online Accessibility Act does not necessarily, has not been passed, the courts are inferring a reasonableness standard here, that if somebody files a lawsuit and you've already fixed your website, well, there are no damages at that point. We've seen a couple of cases that have addressed this. One was up in New York, which is the Second Circuit, found that the claim was moot. This was a case actually, I think in Florida, Haynes v. Hooters. Plaintiff's claims were not moot, even though they had already agreed in a settlement with an unrelated third party to update its website. Now, that's not moot because they agreed to a settlement. It's moot because they actually hadn't fixed or updated the website yet. So, take prompt remedial and corrective action, take these things seriously, respond, and chances are the ability of anybody to actually pursue you in court is going to go down dramatically. We also have another interesting case that is going before the Supreme Court this fall, and it's a question of standing. And we're following this on two fronts, both from an ADA website accessibility issue, but also because this could have some bearing as well on fair housing issues. The two can be somewhat closely related. In this case, the plaintiff is a self-described tester, and she claimed that the hotel's website did not contain enough information about its accommodations for people with disabilities, and therefore was injured by the lack of information on the hotel's website. Neither party contested that the plaintiff had no intention of visiting this hotel. She was just scouring the internet and sending out letters. Does that sound a little familiar? So the district court dismissed plaintiff's claim for lack of standing. The First Circuit reversed, and now this is actually going to the Supreme Court this fall. So stay tuned on that. But if the court comes down and says, if you have no intention of using this business's services or otherwise doing it, and you're just going around and trolling, that you may not have standing to bring a lawsuit under the Americans with Disabilities Act. And I could imagine somebody making an argument for testers in the fair housing realm as well. Okay, so I did promise you all some prompt takeaways, and I will try to get through those quickly. So, I mean, for starters, you have to audit. You have to take a look at your website's current accessibility and create a plan to address and enhance any accessibility issues. This is where you can have a conversation with your website provider or developer and how they're addressing website accessibility. I'm going to put in a shameless plug for .realtor and .real estate. We do actually offer domain names at very reasonable prices to NAR members to have the .realtor and the .real estate. And this includes like template and model websites that we actually do ensure are accessible. So check that out. I think it's at get.realtor. Let's see, include accessibility language in your vendor and third-party content agreements. If you are working with a vendor to put some kind of feature or some kind of widget, some kind of functionality on your website, or just have it working with a web designer or developer to create a website for you, make sure that there is accessibility requirements in the contract, that they have to be mindful of those and deliver that as part of the service that you're paying for. Address ADA website accessibility and indemnification issues in the contract as well. Make sure that they're going to indemnify. If they warrant that they're going to make sure it's accessible, then they're on the hook if they don't deliver that. They're the experts. You all don't have to be. Consult website accessibility experts to create a plan for addressing any of those issues. Include an accessibility statement on your website. We actually have a model version if you'd like to adopt for your own purposes, and ar.realtor/accessibility. By putting that on your website, you're almost creating kind of a safe harbor. You're showing people that you take this seriously, and that if issues are brought to your attention, you will look into them. And that does create some of that intent to remediate that gives you a little bit of protection based off of some of the cases that we've seen so far. If you do receive a demand letter, don't sit on it. Alert your insurance provider and counsel. A forceful and prompt response is recommended. Talk to your insurance companies to see if you have an insurance carrier that provides certain kinds of website liability protection and things like that. Or maybe they can retain counsel to draft a response. Respond in these letters promptly and forcefully to say that you take these issues seriously, and you endeavor to continue to make sure that your websites are accessible, but that you are not admitting to any liability, and also that the law is not established that they can get damages out of you just because of that. Is a good way to respond. Paying a lawyer a little bit up front usually saves a lot on the back end in litigation costs. Take it from a former litigator. We do have lots of great resources as well. We've got some articles on this issue. We have some windows to the law if you prefer to watch videos. And yes, they are closed captioned and otherwise accessible. And we also have a topic page just solely on the Americans with Disabilities Act and how that applies to real estate. So with that, I am going to stop sharing. I think that I'm right about at my time that we had discussed, but I'm happy to field questions if we have time. Sorry, Rhonda, I think you're on mute.
Does anybody have a question? Anybody have a question about something other than ADA they want Matt to answer?
More than happy to answer anything within my competency. I will tell you, I'm not a Louisiana attorney, though. I'm here in the Commonwealth of Virginia.
Can you give us a real quick update on the two big class action suits that are out there that are dealing with commission and buyer agency before you jump off?
Absolutely. So I think you're referring specifically to the Merle and to the Sitzer cases. The
Yeah.
Merle is the national antitrust litigation that was filed in Chicago. It covers, I think, 20 or so of the largest MLS markets in the country. And then the Sitzer case is a similar case that was filed around the same time that only it's brought by sellers just located in the state of Missouri. Their allegations generally are that on behalf of a class of sellers that sold property during a specific time frame in these regions, that they paid inflated commission rates based off of our participation rules in the MLS, that in order to put a listing in the MLS, you have to offer a unilateral blanket offer of compensation. We don't establish what that has to be. All commissions are negotiable, but that you cooperate when you participate in the MLS. Both of those cases are proceeding. We have been fighting them diligently through motions to dismiss, opposing class certifications. In both cases, the class has been certified. And that's not the end of the road. That is not a determination on the merits. All they have determined is that there may be a class of similarly affected individuals, and that the sellers who are the plaintiffs that are named in the case are able to serve that class of people. The reason why this is important is because in class action suits, most of the time the individual damages for people are so low, it doesn't make sense to do protracted litigation. So, we certainly take that seriously and fight it, because the economics of the case don't work if they don't get the class certified. In both cases, we have sought for permission to file what's called an interlocutory appeal just on the class certification issues. In the Sitzer case in Missouri, that the appeal, that immediate appeal was not granted. We still preserve rights to appeal later. And we don't have a determination on the Merle case yet as to whether or not we can appeal just the class certification issue. The Sitzer case, the Missouri case, is scheduled to go to trial in October of this year. And so discovery is concluding. We're ramping up for the motions for summary judgment to try to get some of the claims knocked out or narrow the scope of issues. But we will keep you all updated because we want to continue to fight this. We believe that the plaintiffs are wrong on the facts, wrong on the law, and wrong on the economics. One of the things that, but like I want to continue to reinforce that none of this is a determination on the merits. I would encourage you all to check out competition.realtor, because while we're fighting it out in the court of law, we would really appreciate it if you all were out there fighting it in the court of public opinion. Competition.realtor has all kinds of toolkits about how our practices, our rules, and the local brokerage marketplaces, the MLSs that you all participate in every day, are pro-competition and pro-consumer. They expand housing affordability and access. They foster competition. They are the most reliable and comprehensive source of properties listed for sale. And so that benefits both sellers and buyers alike, helps build communities, and makes it lowers the barriers for entry for new businesses, new real estate brokerages to enter the market, because they can go and just plug into the MLS and have the same access to data and information as everybody else. So encourage you all to do that. The only other thing I'll take away is that we did get extremely good news in the Department of Justice lawsuit. Hopefully you heard in January of this year that the judge found that our settlement agreement with the Department of Justice should still be upheld, and therefore the DOJ cannot walk away from it and try to reopen its investigation and litigation against us as well. Now, the Department of Justice has noted that they would like to appeal that decision, but given how comprehensive the judge's ruling in our favor on that was, we feel pretty good about that.
All right, anybody got any questions on those for Matt? Well, thank you for giving us some time today. I know you need to recover after last week, run from committee to give everyone those updates. And we look forward to hopefully winning all of those suits and having a good outcome for everybody.
Absolutely. Thank you again for the invitation opportunity to present, for your all's attention. And yes, I actually really do enjoy all of those presentations. The legislative meetings were a lot of fun. We appreciate all of our members and volunteer leaders who were able to attend. And believe it or not, if you all thought that was long-winded, I just condensed a 25-minute presentation into about 5 minutes. So.
And again, the competition website address is competition.realtor. Somebody had asked that in the chat.
Yes, very easy to find.
I believe Jeremy has escaped the Capitol and is ready to update us on session.
So there's a lot of moving pieces to this session. There are 21 days remaining, and lawmakers have to figure out a pretty complex fiscal question, which is, do they spend $1.8 billion in surplus money, additional dollars that were unanticipated? I remember when I started covering politics 24 years ago, if this question would have presented itself during an election year, it would have been a no-brainer. That money would have been spent, but it's just not that way at the Capitol anymore. Also, the state has a constitutionally created spending limit. If the state wants to exceed that spending limit, they need a 2/3 vote out of the House and the Senate. And there's some pretty defined lines drawn on that spending. And it's now unraveled the state budget as well. And you've got the governor and the Senate leadership on one side that want to spend this $1.8 billion plus. We'll get to that plus in a moment, on bridges, roads, infrastructure, paying down debt, one-time expenses, just in time for re-election year. On the other side of the coin, you have House conservatives, the business lobby, and many others who don't want to bust the cap. There's already a House budget that's on the move. It's moved to the Senate. It's $154 million under the spending limit right now, which is extraordinary when you look at the cuts to things like early childhood education and healthcare for our sickest and neediest in the state, to be that far under the cap. But that's where negotiations are. And to me, viewing this right now, it looks like the Senate is heading in one direction with the governor and the Louisiana Municipal Association and the Police Jury Association. And you have House conservatives heading in the other direction, along with the business lobby, Family Forum, and a bunch of other folks who have their own tax relief plan that calls for filling the rainy day budget and staying underneath the spending cap. The reason the business lobby loves this idea is because if you fill the rainy day fund, it creates a trigger mechanism where some corporate and individual tax rates will go down. That was created in 2021. So, lawmakers are trying to figure out what to do about that. And while they're trying to figure out what to do with this $1.8 billion in additional money, even more money was recognized this morning by the Revenue Estimating Conference. That's the panel that determines how much money the state gets to spend every year. And they found that there's $322 million in additional money for the current fiscal year, $483 million for the next fiscal year, plus the $1.8 billion that they were debating over to begin with. So there's a lot of money at play, and then lawmakers have to figure out what to do. And there's one other statistic or figure that I want to bring to your attention, and that is 3/4. 3/4. That is the vote threshold for passing a budget in an election year during the last year of a term of state government. A lot of folks don't realize this exists, but if lawmakers fail to pass a budget, which they have done before, they would have to go into a special session. And because it's the last special session before an election year in the last year of a term, the budget now requires a 3/4 vote. So if they think things are tough now at the Capitol, I can only imagine what it would take to get a 3/4 vote in each chamber. So, there are some signs that all is not well in Capitol land. Today, the MFP formula got kicked back to the Bessie board. And if you don't know what that is the annual spending plan for our public and secondary institutions of education in Louisiana. This has happened before. The legislature can kick back the proposal from Bessie, but to see it happen with 21 days left, while the budget is in play, there are questions about the spending cap. Things are getting a little shaky. All the budget bills have now left the House. While y'all have been meeting, the House passed the annual construction budget, which is really kind of a big bargaining chip in all of this. The other kind of big piece of legislation to watch is Senate President Paige Cortez has a resolution that would lift the spending cap and allow for all the spending that we're discussing. So there's a lot going on. Of course, I think a lot of folks are starting to become more focused on the upcoming election year, which promises to be another doozy, at least in terms of the governor's race. To me, one of the more interesting things that is happening are that the candidates and the committees involved in the governor's race are up on TV in unprecedented amounts right now. It's not unusual to see one candidate get on TV early. 8 years ago, when the last open seat for governor, Scott Angel had a media buy up in February, but he was alone. So here we are 8 years later, and John Schroeder has had a statewide media buy. He just added $1.1 million to it. Jeff Landry has had a really interesting statewide media buy on TV. He's actually rolling his commercials out region by region. And it's a similar commercial based on crime, but he kind of knocks a local elected official in each ad. In New Orleans, he knocked the mayor. In the Shreveport ad, he went after the DA. So it's a unique approach to a statewide rollout. Meanwhile, Stephen Wagenspack has seen commercials on TV from a PAC that is supporting him, that is Reboot Louisiana. And Hunter Lundy is up on radio, and I think he's going to be up on TV as well before the end of session. So a lot of activity in that race. I think if there's any one big trend to watch when you're trying to kind of figure out this field for governor, it is going to happen on the right side of the field. And if you don't know, the field for governor is pretty darn close to set. There is an independent from Lake Charles named Hunter Lundy. He's an attorney. We're going to talk a bit about him. Among Republicans, there's Attorney General Jeff Landry, who's leading the money race. He has enviable name recognition. Treasurer John Schroeder is running. We got two legislators, and Sharon Hewitt and Richard Nelson. And on the Democratic side, former Transportation Secretary Sean Wilson. Something to watch for with Jeff Landry, who is the leader in this race right now. Look, if this race was held today, it would be a runoff of Jeff Landry versus Sean Wilson. Those are the kind of the fundamentals of how these gubernatorial races work. But Hunter Lundy is an interesting guy to watch. He has already put a couple of $1 million of his own money into this race. He has a very strong base of support among Pentecostal voters. And he's also raising a good clip of money from trial lawyers. He is a trial lawyer himself who has had some sizable settlements in a family of trial lawyers. And he's raising money off the trial bar in Mississippi and Louisiana. But what's interesting is he kind of runs to the right of the field. He is a guy who hangs out with candidates in other states that talk about Judeo-Christian forms of government. So you could see a Hunter Lundy get to the right of Jeff Landry and kind of peel some votes off when everyone else is probably going to be pinging Jeff Landry pretty hard. The Democratic side of the field is completely different. I don't think you're going to see Sean Wilson go up on TV anytime soon because, frankly, he doesn't have to. He's the lone Democrat right now. The question is just how strong is Sean Wilson going to run in this primary? It could be 35, it could be 38. I think a lot of folks are hoping that he at least has the same showing as the governor. But don't sleep on the statewide elections as an association. I don't know if you've taken the time to absorb exactly what's happening, but we're going to see a practically clean slate of statewide elected officials, maybe I think minus 2 positions, the lieutenant governor and commissioner of agriculture. Everything else looks like a wide open race, which is a major shift in Louisiana politics. And it's also going to be a major shift in party politics. I think right now there's only one marketable Democrat running in all of those races. That's all of the statewide elections. So there's a lot going on, a lot to be settled by the session. And I think that's going to color the fall elections as well. I'd be happy to take any questions if y'all have any.
Jeremy, the change on the spending cap, that's been put into place recently, has it? It's been within this term, maybe the end of last term is when they put those restrictions in place.
Yeah, the spending limit is a fairly new concept in the Constitution, and is part of this kind of wave of conservative budgeting that we've seen kind of take over the Capitol over the past 3 or 4 terms of state government.
And can you talk about the difference between surplus dollars and one-time money, and why there's the battle over it, because the restricted use on those funds?
Yeah, so when the state finds additional dollars, there are some automatic deposits that have to be made into the rainy day fund and some other accounts as well. But lawmakers do have a certain amount of discretion with a certain amount of these dollars. And so we hear this argument over and over again every year about using these one-time dollars, because these surplus dollars, they're unexpected. That's not expected to happen again. There are one-time dollars, and that they should be used for one-time expenses and not recurring expenses, that the state shouldn't get into the habit of paying recurring expenses with one-time dollars. So that's an ongoing debate, and I think that there's enough support at the Capitol now that's what we're going to see. Is we're going to see some form of placement of one-time dollars on one-time expenses. But I'm glad you bring this up, because the first thing I was supposed to note that I think is very important for everyone to realize is that everything we're talking about right now, about the budget, the spending cap, these elections, they're taking place underneath the umbrella or in the shadow of a much larger issue that we didn't talk about. And that happens in the next term of state government in 24, 25, and so on. Particularly in 2025, we're going to have a temporary state sales tax that's going to roll off the books. It's temporary in nature. That is $400 million annually that the state is counting on right now. And I can guarantee you that the legislature will not have an appetite to replace that with other new tax revenue. They won't have an appetite to renew it. So lawmakers have to figure out how they're going to address that fiscal cliff. At the same time, federal dollars for COVID are dried up. The federal transportation money is going to dry up by then. You're going to have inflation is going to continue to do its thing. So we're going to have a reversal of fortunes here very quickly. And, if lawmakers can kick the can down the road, I think historically they have done that, and they will always do that. So, all of this is building towards something. This isn't just another round of he said, she said at the Capitol.
So, your opinion, the worst bill of the session? I think we all have our own favorite worst bill, but
I gotta say, I was really surprised that the House of Representatives chose to cut early childhood education as much as they did. You know, the cuts that they delivered to early childhood education could endanger thousands of seats for these early childhood education programs. And if you look at some of our worst problems in this state, aside for poverty, I don't think that it could be more important of a priority for Louisiana than early childhood education. And it's beyond me how that ends up on the chopping block and in the politics of all of this. A bipartisan issue, nonetheless. Seems like in other states it's a moral imperative, but in Louisiana somehow it became part of the politics. So I'll go with the budget for now.
Okay, and I know we had a question in the chat about HB 606. It looks like it was returned to the calendar today. Kim, do you have any insight
Yeah.
on?
606 is the bill that if you have a single family residential rental and there are 2 police reports with violent crime or drug offenses adjacent to that property, you can terminate your lease. And then if it's on the property, in a multifamily property, you could terminate your lease. It also at this time requires security cameras and lighting, which makes it possible for those security cameras to film everything on the property, and some disclosure requirements about criminal incidents in the general vicinity of the property to be disclosed to prospective tenants. The bill came up on the calendar today. The author immediately put it back on the calendar. He since has filed some amendments that take out the security camera and lighting requirements, and he is going to supposedly bring it back up on Monday. We believe we have the votes to have the bill not move forward in the process, and we have a call to action ready to go should it be needed. But we are hoping that we don't have to do that, and we can be respectful of the things that brought this bill to be filed. So we think we have taken care of.
Does anybody have questions for Kim or Jeremy at this time? You can unmute and ask freely. Nope. Wow.
We got lucky this year. There hasn't been a lot, no independent contractors, no sales tax on services, no licensing issues. So we were good. Next year will be great times,
Oh yeah, because we start all over.
right?
All right. Well, the last thing I'm supposed to do is remind you all that we are having an in-person broker summit in June. The information to register is at larealtors.org/broker-resources. And if you have a problem with that, I know Lori has attached the information in an email that went out earlier this week. We hope you will join us. We have a phenomenal instructor. He's got 2 2-hour classes on the first day and a full day class that will lead towards your certified residential brokerage manager designation. It's on exit strategies. It's information that you can use yourself as a broker or pass along to some of your senior agents who may be looking to get out of the business. We will also be going to the Astros game, or you're free to roam about Houston on that first evening. The room cutoff is May 24th. So even if you don't register today, the most important thing to do is go get your room. And Donna just put the link in the chat for everyone. Does anybody have anything else they want to bring up? Tony, you got anything?
Just happy birthday. Rhonda officially turned older than me today, so.
But I'm still not older than Norman, so that's all that matters.
And you're not
We
older.
joke, y'all, because we're all the same age, so Norman, Tony, and I have a running joke about who's the oldest and who's the baby. And right now he's the baby. So,
Baby.
well, with that, I hope to see you all at the Broker Summit in Houston next month. And if I don't see you there, well, you're just gonna miss out. And we'll see you in the third quarter with the call. If y'all have ideas, please send them in. I know we got a couple of ideas this month. The fingerprinting was one, so we felt like we had that covered. Someone has put recruiting and retention. It's kind of hard to talk about that on one of these, but we'll see what we can do to get you some information on that, or maybe get a special class for you guys next year, or maybe something at the fall event. Cindy, do you want to give them save the dates for the annual meeting?
Bossier City, the Horseshoe on September 18th, 19th, and 20th. We're riding with the brand, and then installation the evening of the 20th.
And y'all, look, we got a $69 room rate, so I know
65.
gas is 65.
Mm.
Well, I know gas is expensive coming from New Orleans, but y'all can carpool up. The room rate's not an excuse not to come to Shreveport. Plus, we want to see all y'all. All right, well, we will adjourn the meeting unless somebody has something else. We will see you guys later. Have a good
Have a
one.
good day.